reasons we feel that costs are a big concern on the part of the clients is because many times when we are actually contacted by clients to take on a lawsuit on their behalf is that we're asked to take it on contingency. So that immediately clues us in that they're very concerned about how much it's going to cost them. In their minds, they feel that if the attorney takes it on contingency, the attorney will become their advocate without them necessarily having to pay for it. That is really, in my opinion, a very bad position to take, because when an attorney takes a case on contingency, the attorney is looking to make his or her money as fast as they can with the least amount of work as possible. Look at the cases that are being taken on contingency: personal injury, a car accident, medical malpractice, legal malpractice sometimes. The reason why these cases are all taken on contingency, because 90% of the time there's some sort of insurance policy that will kick in for purposes of providing coverage for the lawsuit, whether it's coverage for the trial preparation itself and ultimately the trial, and for the damages. So what happens is someone who's doing personal injury or someone who's doing medical malpractice, the first thing they will do is they will contact the insurance company and try to settle, try to come to an amicable solution that will, on the one hand, compensate the attorney's client for any damages incurred, and on the other hand, allow the attorney to get in and out as fast as they can. In our opinion, taking a case on contingency is almost a conflict of interest, because what you're doing is you as an attorney are putting your interest to get in and out as fast as you can with the least expense as possible. It puts the interest of the attorney against the interest of the client. We've had situations where the client wanted to continue to litigate, and the attorney didn't want to litigate because he felt that at that point the settlement amount was the best that they could do, both for him or her and for the client. Doesn't necessarily mean that the interests are at odds, but unfortunately when you're taking a case on contingency, the interest of the attorney somehow gets involved and therefore affects the attorney's neutrality and the attorney's ability to continue to advocate in the best interests of his or her client.